I think it's on.
Can you hear me now?
Yeah.
Let me check my hair and my makeup and get going. Well, as I started to say before we found out the mic wasn't on, at the first City Commission in November, I requested that staff and the City Attorney review the November vote on the Melton property and provide the Commission with options to go forward on this matter. That was accomplished by way of the memo to the City Commission received last week from the City Attorney and the City Manager, and you all had the opportunity to review it fully, I take it. I would like to have the City Attorney go over the options in the memo with the City Commission. And then once that is completed, the City Commission can make comments or ask questions. We won't take any action today, but we can tomorrow at tomorrow's commission meeting, and I hope we can move in that direction also. But before council begins, I want to ask the commission that during public input after the work session, please do not make any attempt to debate or answer public questions. We are in litigation at this point. Our situation actually places us in a position where I could call for a closed session in this matter to discuss pending litigation. However, we will discuss this in a public forum. Counsel?
Mr. Mayor and Commission, thank you. Before getting into the essence of the memorandum that you have from both Mr. Mercedes and myself, there is one substantive change, which is when this memo was drafted and circulated, we had a copy of a draft complaint, and the memo references the essence of that draft complaint. Since then, they have filed suit. We have approximately 14 more days before we need to file an answer. So it is imperative upon this body to give direction tomorrow night, because you don't meet again until the second Tuesday, obviously, in January, which will be after the 21 days that we have to file an answer. Having said that, we have attempted to bring to you, by way of background, that we are talking about a site that has been an industrial site for in excess of 100 years. It has been sold by S.D. Warren to Melching Incorporated, subject to a number of deed restrictions, covenants, and obligations that Melching has to Sappy, that what was brought before you this year was an initiatory petition, and frankly the comments that were made both before and after the election have changed somewhat as to what the intent of the proponents were. As you'll recall, many of the comments especially early on, were that the initiatory petition was intended as simply an indication what they would like the City Commission to do, what action they would like the city to take. The more recent comments have been, now that the voters have spoken, this is what you must do. That has put us in the city in a position of, we either need to proceed on litigation, and we have outlined several options as to that litigation. The first, we could take the position of some of the early proponents that it is simply advisory, and we could indicate to Melching, we agree it's not binding on us, the litigation is essentially done, the rezoning would not, would be consistent with what it is right now, which is I-2, or industrial use. Alternatively, we can oppose that litigation, and so essentially, no, we think the voters have spoken, this is what the zoning is, subject to some qualifications that I'm going to have in a couple of minutes. We would certainly encourage the proponents to participate in this lawsuit, because whatever the decision of the judge is, as to whether this is binding or simply advisory, is binding on all of the city residents. It's not just binding on Melching and us, it's going to apply to everybody. So if you truly are interested in this, the time to do something is to join the litigation now. They do that by hiring a counsel and filing a motion to intervene. Whether the judge would let them intervene or not, I don't know. But if they want to participate and they want to say this is important to us, that's their remedy. We have also laid out for you that it may be appropriate to consider having SAPI join in this litigation. And the reason we lay that out as an option to think about and look at is if we fight the litigation and if we prevail, Melching loses, and this is going to become zone waterfront marine, it has serious implications on the deed restrictions and the other restrictions included in the deed from SD Warren to Melching. For instance, it makes it very difficult to have an entire portion of this property, which the public is not supposed to be on, subject to the deed restrictions, and yet it's zoned for a hotel and restaurant. Which one's it gonna be, Judge? It's tough to do both. Whether we wish to pursue that by adding SAPI to this litigation obviously compounds and makes the litigation substantially more difficult, substantial and probably more expensive, but it is something, if we're gonna go through this fight, and we're gonna fight this, you know, we need to consider that as a possibility. We have also outlined for you options for the city commission after the litigation is completed. Those include, in particular, if the zone change is not valid, if the court rules with Melching that it is not a proper way to amend the zoning ordinance, then certainly the city commission can direct city staff to start the process on rezoning the property. And that's by way of a staff recommendation, staff investigation, recommendation, what should the appropriate zoning be, hearings in front of the planning commission, both normal meetings, but also, I presume, especially the context of this, there will be one or more public hearings, a recommendation from the planning commission to the city commission as to a potential zone change, and presumably a vote by this body at some point in the future. Likewise, there's some other options that can be pursued either as part of that or as staff with Melching, and those are things like contract zoning, and likewise convincing Melching that it's in their interest to submit a PUD. The problem on both of those is they are going to be time-consuming and problematic. Problematic in the sense that Doug Melching has told you, his representatives have told you, and they have indicated to others, they have somewhat of a difficult time coming forward with a PUD or a contract zoning when they don't have somebody in place ready to go to do something. They are concerned about binding themselves in to say, in this 10 acres, we will do X, when they don't have anybody to do anything on the entire 100 acres, other than what he is doing now, which is basically deconstruction, nominal amounts of other industrial uses, which don't result in any buildings being built, etc. That will be difficult for them, probably in a better position as time goes on, to be able to say, okay, I now have somebody that wants these 5 acres, these 20 acres, thus I know I can agree to a zone change contractually or by way of a PUD to do something in this one particular area. I still don't know what I want to do with the rest, but we can sort of piecemeal that. And certainly that has been consistent with a number of other large tracts of property where developers have come and said, we aren't really sure, you know, give us some flexibility. We need to work with some stuff. And come back and forth, you know, to this body, to city staff, etc. I am certainly happy to answer any questions that the commissioner mayor might have. I'm sure Mr. Mazzei would also, or further expound on something.
Well, my key question is, I mean, given that we're gonna be spending, no offense to you or your profession, but since this has happened, we will be spending money on lawyers, a lot of money that we don't have. Is it all an academic exercise? Because, you know, unless I'm missing something after being on the planning commission for 11 years, there hasn't been an abandonment of the historic use, and whether we had rezoned this to something different in 2009 or doesn't change the right of the current property owner to use the property for his current zoned uses as a legal non-conforming use. So could you, am I wrong?
No, you're right. Commission, what Commissioner Spataro is specifically dealing with is footnote 1 on page 3, which talks about that a property owner has a vested right in the existing zoning. And all successor owners have that same vested right. Simply because there's been a transfer from one owner to another does not eliminate the legal non-conforming status of real property. The zoning change stays with the property, etc. So that even if we changed it today, or a circuit court agreed with us and ruled that mulching was wrong, it doesn't change the fact that mulching and successor owners continue to be able to use it for industrial property. Where we are going to have the possibility of future litigation is exactly what does that mean on exactly what piece of property, and are we going to have fights over, well, in this 1 acre, you didn't use it for industrial, it was parking lot. Does that make it part of industrial, or are we gonna try and take the position that it doesn't? This was an office. It's connected to the industrial, the office's sole purpose was to service the industrial use. Does that mean that it's industrial or not? Are we going to litigate every one of those? If the litigation ends with Melching is correct that the initiatory petition is not a way to change the zoning, we can resolve some of those issues by way of either contract zoning, where the parties agree that this area will be used as offices, this area will be used for open to the public, etc. And I'm being hypothetical on what those might be. But if Melching and us agree, then that whole issue of the legal non-conforming is not going to keep getting litigated in those areas, because the parties have agreed. And essentially Melching has agreed, I'm willing to give up industrial for this portion, and city, that's acceptable. But otherwise, you're right, we're going to have litigation, at least the potential, for some period of time.
Commissioner Markowski?
Regarding the land transfer, does that apply if it is sold as one contiguous piece of land, or if it's also divided up?
Doesn't matter. It may change the likelihood of succeeding in litigation on whether or not it's the legal non-conforming. If we're, for instance, we're talking about just the office, and the office was used as an office before and is used as an office later, it may make our argument a little better, but as a strict legal proposition, it doesn't matter.
Commissioner Turnquist?
Is there any advantage to wait to see what the circuit court decides and then plan our next step?
Well, what the circuit court does next depends on what we do. If we don't file an answer, then a default will enter, I would assume in about 22 days, and an order entering that Melching is right because the city has not filed an answer to it.
So we have to either be for or against
Yes.
what's on the table.
Yep.
We just can't be mute and wait to see what the circuit court decides.
With probably one exception. If within the next 21 days, a group of citizens file a motion to intervene and are granted the opportunity to intervene, and they defend the city's action, then that litigation would go forward. I would not expect that to happen within what now is probably a 14-day window. That would be unusual. Normally, interveners come in after an answer is filed. They need time to hire counsel, get counsel up to speed, etc.
Go right ahead, Commissioner. Follow-up question.
Well, this is to Brian probably. I've been told that, over this time frame, we have had some communication and negotiations with Melching, Mr. Melching. Has he changed his position during this time at all? Do you see a spot where he might soften, or is he very, very adamant about his stand, which was adamant to paper?
I haven't had a conversation with him or representatives from his company recently, and it's probably due to the fact that vote was passed, or the proposal for was passed in November, and guess he was preoccupied with this matter.
Council, you had set out options A, B, C, and D as far as response to pending litigation.
Yes, sir.
Now, if we lean more to one of the specifics, A, B, or C, could we also include adding SAPI into, or would there be a benefit to that? Let's say if I was leaning towards option C, where we litigate the issue and encourage the proponents of the initiatory petition to join the litigation, would there be any benefit as well as adding SAPI, or do they stand alone?
No, I don't view, in my mind, it's A or B, and if you do B, it's B, B and C, B, C and D, B and D.
All the
Any
above?
of those are fine. Once we decide we're in this lawsuit, we're in for the fight. And I think there are benefits, and that doesn't probably have to get decided tomorrow night, whether we add, or other than direct us to start looking at ways to get SAPI as part of this litigation. I think there is merit to the circuit judge being able to look at also the deed restrictions and say, okay, if I'm gonna impose, if the city's zoning ordinance is going to be effective and it's gonna impose these obligations on Melching, I've gotta figure out a way to relieve them of some of the obligations under the deed restrictions. I judge whomever, cannot put Melching Incorporated in a position that they can't comply with both the zoning and the deed restrictions. Would expose us to substantial financial exposure. IET.
You're not saying it's not possible, it just wouldn't make much sense for the
I-
judge to decide that.
It would be possible, and then the second lawsuit would be Melching saying, I want money. I can't use this property for anything anymore, or some portion of it.
We have the manager.
Can I just say something in response to what a question that Commissioner Chernick was asked earlier about waiting, could we wait? I think there's really maybe two questions there, or two issues there. One is with respect to the litigation, and as Mr. Schreier said, we really need to move forward and make a decision on what we're gonna do in that regard. But then, the second piece of that really is, what do we do with the potential rezoning of the site after the litigation? And I think what Mr. Schreier is saying is we can wait, we really wait until after the litigation is resolved to determine what steps we take in that regard. If that helps.
Council, if we did select option C, where we encourage the proponents to enter as well, how would that contact be made, or what would be the mechanism for them to enter?
I think city staff probably could notify representatives of the proponents. I think they're sitting in this room. I think they have also probably read the MLive articles, probably made comments on the MLive articles. So knowing that if they really care about this, they better get involved, shouldn't be a big shock. What they will have to do is retain counsel, and there's gonna have to be an organized group, or an individual could do it. But they're going to have to retain counsel, and counsel is going to have to file a motion to intervene. It'll get scheduled for a hearing before the judge. Presumably our position would be, we have no objection to the intervention. I don't know what Melching's position would be. And if Melching objects, then the court will decide, do they get to intervene or not? Do they have an interest different than ours and different than Melching's? And I would, this case, if they can articulate that this group of people, individuals, corporate body, whatever, were proponents of this petition and did things to push it, they may well have sufficient standing to intervene.
Vice Mayor?
This is a question for the manager. I just heard that regardless of the choices we make, unless we negotiate a change with the Doug Melching, that basically this is a legal non-conforming use, regardless of what we rezone this to, unless there is a change in state law or the judge issues a precedent that would have the effect of changing state law. So my concern becomes financial. We have to protect the financial interests of the citizens of this city. And, you know, we have another matter before us tonight that we wouldn't even be discussing if we had the same revenue that we did 5 years ago. So my concern is, so we can help make a more informed choice on which of these options that have been suggested we take, is what is our obligation out of pocket for legal bills? And is this something that would be covered by our risk management coverage, or are we, because of the nature of this type of litigation, are we exposed to the full cost of the legal bills?
I think you have several questions, let me try to answer.
It all comes down to money.
With respect to the amount of money that would be spent on this litigation, it's really anybody's guess, but I think what Mr. Schreier tried to point out is certain options would probably carry a different financial burden to the city. One, I think he points out in that under that scenario, it would probably be much quicker, it wouldn't be as expensive. We kind of went through that, but you know, even in that case, finite dollar amount is not attached to that. And I think it's difficult to attach a finite dollar amount to the litigation.
Well, I'm thinking in terms of, I believe only the mayor was here at the time to remember this. We went through a eminent domain taking that kind of blew up in everybody's face. And those legal bills quickly hit over $250,000. That was out of pocket. And that's what I'm looking at is worst case scenario, you know, what's our maximum out-of-pocket exposure for this, or is there at some point when our risk management, I mean, you know, if it's technically there isn't a limit because it's not covered by risk management at all, that's what I'm getting at.
Okay, I think I'm following you now, and I may need to ask him for some help here, but what we do in cases like this when lawsuits are filed, we provide these lawsuits to our risk management group, which is essentially our insurance company. And then they determine whether or not there's coverage for the claim. I don't believe that they have made that determination yet. And I think it's indicated in here that we think that they probably will not, that they will probably deny coverage because of the type of claim. If that is the case, then we will be responsible for whatever the costs there are with this case. Even if they do provide coverage, we have a retained amount that would be deductible, if you will. And I believe Tim, how many is it, $100,000? $150,000. So we will pay the first $150,000 of litigation.
And that's assuming that they actually say we'll cover this litigation.
Correct. I'm sorry, I didn't understand your question.
Right. No, but that, I mean, when we're making these decisions, I think we need to know the dollar amounts of what we're talking about, particularly in light of the other financial choices that we have to make over the course of the year. That every dollar spent on this litigation is a dollar that's not available for something that's very important for the, you know, the benefit of the citizens of this city and the operations as far as things that we take for granted, like potholes getting filled and the grass getting mowed in the parks and things like that. So, thank you.
Commissioner, I don't know if this is a appropriate comment at this time, but I just look at that property as so much potential for the city of Muskegon. And it seems to me that we're drawing a line in the sand, and some are on that side, some are on this side, and good solutions involve some compromise. We've talked about some things, and this is a wild idea, and I have no idea whether it would be accepted or not, but the west end of that property really has nothing on it from what we can see from the road. The citizens would like to have access to the lake from Lakeshore. We have had a number of inquiries about people wanting to buy Fisherman's Landing down at the other end. I don't think we've ever had any opposition that that's more of an industrial site down there. If that kind of situation exists, with the people who are promoting the rezoning, if the city were to buy the west end, I don't know how many acres, and offer to relocate Fisherman's Landing in that end, providing access to the water to everybody, and still have some commercial, because we're going to need income in the city. And I don't know, standing hard and fast I don't think is good. I think there has to be some solutions that's good for the people and good for the city.
Vice Mayor. I don't think the seven of us up here are standing hard and fast. I mean, let's think back to how this has played out up to this point. We insisted that there be a master plan for this site. Mr. Melching, after some reluctance, has been negotiating with SAPI, with the DEQ, with the city of Muskegon, on the long-term plans for the use of this site, including mixed use. So, I mean, from the very get-go, there has been a willingness to be flexible, I think, on our part and on his part. But we were forced into this situation that instead of allowing this to play out over the course of 2 to 3 years, which is what it would typically take with something this big, this complex. I mean, it's at least a year before he's even finished with demolition. It's probably a year after that before the DEQ signs off on anything going there at all. So, you know, instead of allowing ourselves to take advantage of that time that is going to be there regardless, to negotiate an outcome that is acceptable to the property owner, acceptable to the community, we've been put into a situation where we're being asked to force an issue instead of negotiate an issue. And from my perspective, when you start forcing things against people involuntarily, you usually end up with much worse results. I mean, and I don't disagree that having the west end available or parts of that site available for public access would be wonderful. I don't know how we do that without buying the property, and I'm not sure how we buy the property unless somebody gives us a lot of money. So I think we would be better served and would be demonstrating more flexibility by trying to settle this lawsuit as inexpensively as possible and continue to negotiate with the property owner for a positive outcome from the community. I don't see that as being inflexible. I see that as being flexible.
Well, I see us buying the property by selling Fisherman's Landing.
We can't sell Fisherman's Landing. The way that was funded, that uses state and federal funds. They have final say on whether or not that property can be what's called converted. So we went through that exercise once 10 years ago where a private developer provided land at their own expense, was going to build a duplicate facility at their own expense, and the people who control the deed restrictions on Fisherman's Landing said no. So even with that, they certainly would not allow us to, you know, use public dollars to do that, because public dollars were used to create Fisherman's Landing in the first place. So I mean, I understand where you're coming from that, but I don't see that as a viable way of generating money to buy a portion of this property.
And
before we start talking about potential collaborations, cooperations, and development of the property, we have this little bugaboo called a lawsuit that we have to wade through. And what occurs with lawsuits is that parties don't talk, and now we have to go see the judge.
Out of fairness, I am comfortable that our office and Mr. Melching or Melching Incorporated's council will have ongoing conversations. I think the mayor's point, though, is right, is in the absence of a decision, both parties are going to be coming from a different perspective. There may be a willingness to try and do something, but we think we're right, they think they're right. Both can't be right. And who's got the power is part of that conversation.
I'm not sure.
And it runs its own time schedule. Litigation runs on its own schedule. This type of case, probably, I would guess, a resolution late spring, early summer.
I'm sorry, from what I was reading in the memo, I wasn't sure that I garnered that there was any option of, direct settlement prior to just allowing it to be litigated.
I think
Whether or not that's, you would consider whether it was even an option.
it is always an option. I don't think it's a very, I would not, at this point in time, I certainly would not want to tell you, I think this case is going to get resolved, because I think I'd be misleading you at this point.
Mr. Manager?
I guess maybe to dovetail on what John said, though, I think a settlement could include a couple things that Mr. Schreier said earlier, and that with respect to contract zoning or a negotiated PUD.
So commissioners, as we're, Commissioner Turnquist, please.
Irregardless, as we as a city decide to go in one direction or the other direction, and the zoning gets changed, Mr. Melching still has the option to continue on with I-2. That's, I think your statement was earlier.
If it is done without his consent, we do it by way of a contract zoning or something like that, or he comes and the parties agree to a PUD that calls for industrial in this area, commercial in this area, etc., then we avoid what I'm going to refer to as almost the second round of litigation, because he will have given up his rights to do industrial or perform industrial services on some portion of the property. Now, the alternative is he may say no.
We don't know.
We don't know.
This comes back to my understanding of the settlement option. Is mediation something that would be put in as a suggestion at the point of us submitting our response to litigation, or is that something that would not be available until later?
Facilitative mediation could occur in a couple of different ways. One, the judge could order the parties to go to facilitative mediation. Alternatively, counsel for both sides could essentially recommend it and thus require it. What it takes, though, to be successful is a willingness on both sides to compromise. And at this point in time, I can't tell you how willing Melching Incorporated would be to compromise, and I can't tell you how willing the city commission would be to compromise. For instance, I neither can predict whether Melching Incorporated would be willing to say 50 acres down there can become commercial, nor do I have the ability to say, and the city commission would agree, that 50 acres remain industrial. I've not asked the question, and I've never heard a consensus.
I have one more question. You read it all the time, it's repeated, that the city dropped the ball in 2009 and we should have rezoned then. If we had tried to rezone then, Sapley would have started litigation.
Sure.
That's not a certainty either.
No. No, and I would expect Sappy would have asked for money, and two would have said you can't do it anyway. And you don't have insurance coverage for that type of case.
So that, I mean, that's kind of where I'm coming from when I mentioned mediation, is clearly this is gonna have to come down to a negotiation at some point. And if we can suggest a negotiation on the front end instead of the back end, I think that we're gonna provide some kind of resolution to our finances and to residents. So, that's something I'm
But right now, we have to make a determination on how we are going to enter the fray with the options that we have before us.
How many days do we have before we make this determination?
I haven't, I'm sorry,
No, go right ahead, Council.
we have approximately 14 more days to file an answer. Given that you don't meet again until the second week in January, I would at least like an indication to file the answer.
You did say you and Melchi would be in talks.
Sure.
During that time. Is there a possibility that he would be, due to good talks, let's say perhaps, that you could come to some type of conclusion and just come back to the table, maybe even reconsider and drop this lawsuit and start from the beginning again?
That is always a possibility. I would not expect that to occur. If your thought is do it as opposed to filing an answer, that's not gonna happen in 2 weeks.
Okay.
That's gonna be a much more lengthy conversation. And at some point, the court is going to say, let's go, parties.
For consideration of things to go, how have our relations been with Mr. Milchin as of late? I know that, well, I've tried to, I've tried to contact him several times myself, just to meet the gentleman face to face, and I have not heard back from him. And this is prior to litigation, so I just wanna make sure that we feel that we're on good footing with him as opposed to, putting a hand out and not being done.
I believe all the conversations and the meetings that I and our staff have had with Mr. Melchin have been very cordial, and I think for the most part productive. And I don't think that has changed. Now, I haven't talked to him, as I mentioned, I haven't talked to him since the lawsuit was been filed. But up until that time, they've been, as I said, cordial and very productive.
And I would reiterate the same comment relative to conversations between our office and council for Doug Melchin and Melchin Incorporated.
Commissioner?
One more question, I have to stop. But within the next 14 days, are you saying we have to choose between A and B?
Yep.
We gotta go one way or the other. There's no option.
I've either
Gotta
defend
do
the
one or the
lawsuit
other.
or I've got to,
You can't be mute.
to that effect. If I'm mute, then it's A. If we don't file an answer, then there's no reason not to call Melchin's counsel and say, prepare an order that we agree the zoning was not changed by way of that initiatory petition and vote.
So, Commissioners, we need to be able to come to some type of consensus so that we can give council direction which way we're going to proceed, so we can put it on the agenda for tomorrow's.
I know we have a typical order of proceeding, we try to do things and then request for public comment later, but is it possible to maybe entertain some public comment?
No. We will take public comment, but
Not that we have to.
we will remain silent and not engage because of the lawsuit. We'll be making our determination at this point amongst ourselves as this is being considered. Commissioners, could you use the evening to give further consideration to these options? And then we could attempt consensus tomorrow?
Good idea.
Okay. So rank them. And we'll have further questions for council tomorrow. Do your homework. Would be before you. Okay?
Our email is going to whom?
Pardon me?
The email will go to whom?
No, we'll talk about it tomorrow.
You're asking us to,
No, just rank them, come back, we'll talk about it again tomorrow, and we'll give direction at tomorrow's meeting.
Yep, please do not do a variety of emails back and forth amongst each other. That wasn't, you got to count four.
Right. Next item on the agenda is senior transit.
Steve, will you have copies of the attorney's opinion available at the clerk's office? So tomorrow, when you're entertaining your discussion, we'll be able to see what you're talking about.
The communication is covered by attorney-client privilege. It is provided to the seven of you. The seven of you have the option to waive that privilege and allow anyone and everyone to see it, or you may keep it for the seven of you.
Give that consideration as well tonight, and we'll make that determination tomorrow. Vice Mayor?
How can we see it before then?
Just a clarification on that, that's something that we would have to vote on collectively to say we're gonna release that document or not.
That's correct.
That is not something that as an individual on this commission, we can choose to release that on our own initiative. So I think if we want to release that document, and perhaps, you know, I would wait for our attorney to perhaps provide some guidance on there before we did that. But I think if we want to have that be a public document, that we need to discuss it in open session and take a vote on whether or not we're gonna make that public or not. Because it would breach the trust amongst ourselves if we violated attorney-client privilege without saying we're gonna waive it as a vote of this body. So I do think we should have that discussion. Unless the attorney says that's a really stupid idea, I would suggest that for the sake of transparency, having those options available to the public is not an unreasonable thing to do, but you might correct me.
My general preference is when I provide advice to the seven of you is for the eyes and ears of the seven of you only. On this particular memo, I view it to be somewhat unusual and was drafted with the possibility and or concern that it would be seen by people other than the seven of you. So I don't know that there's anything in this memo that I would find so damning that I would suggest you not do it. I will reiterate though, my general communication is something only for the seven of you and does include information that is not publicly known and would be damaging to the city if publicly known.
Again, I will suggest that you give it consideration. There doesn't seem to be that much objection to it, but I would support its release, but after we have discussed and reached a consensus tomorrow for direction.
Yeah, what's good, do as good as tomorrow.
There's no point in releasing it tomorrow.
Folks?
Well, I think this, yeah, I think
That's just my preference. I'm throwing it out for discussion right now. I mean, we can.
well, I mean, what I tried to get when I was asking the city attorney earlier is, I mean, I'm not sure how many times we can say it before it starts to convince a few people that regardless if we had changed the zoning in 2009 or 20 years ago, or changed it tonight, or did nothing, and, you know, unless state law gets changed or a circuit court judge is willing to set precedent, the fact is that this is a legal non-conforming use, and that's gonna continue to be the case regardless of what that zoning may get changed to, unless we are successful in negotiating some alternative with the property, which has been my position all along. So, you know, to me, it doesn't really matter if that's available to the public or not, because our response to the lawsuit, unless some judge decides to really go out on a limb, isn't going to change the outcome in the fact that this is a legal non-conforming use and he can use that property for industrial use. Our best outcome is to sit down in good faith and negotiate with this property owner a better outcome than that. So,
Well, I would entertain a motion
I would like
to release the information to be filed with the clerk for public access.
I would move that in regards to the memo in question, we waive attorney-client privilege and allow the document to be placed with the city clerk for inspection by the building.
Do we have a roll call, Madam Clerk?
Vice Mayor Spataro?
Yes.
Commissioner German?
Yes.
Commissioner Waringo?
Yes.
Commissioner Chirkowitz?
Yes.
Commissioner Markowski?
Yes.
Mayor Gallagher?
Yes.
Motion passes.
And we will file that this evening, and they'll be available tomorrow. Thank you.
Would be on the internet.
They're asking for the
It could be tomorrow.
Thank you.
It'll be in the clerk's office in hard copy.
Did you hear that?
Hard copy.
In your office, hard copy.
I was requested to put it on the internet. No? Okay. Thank you.
You received the city manager's recent memo regarding senior transit. It was tabled from the last commission meeting as it brings up issues of budget and finance and per our commission rules that needs to be discussed in such a form and giving staff time in order to prepare for responses. Just as some background, you weren't on the council at the time. If the commission recalls that when the CDBG funding was presented to us, I believe $45,000 of CDBG funding had been eliminated and repurposed, which typically had gone to senior transit, and those monies put into other uses, such as senior weatherization, where we have seniors living in substandard housing in order to allow them to remain and not get cold in the wintertime. Other programs such as emergency home repair for impoverished families, for the most part, where we would replace furnaces, water heaters, and roofs, and those type of items. Because those monies were supplemental to regular city funds that made up the other share of the approximately $76,000 to run the program. It was slated then for elimination, especially given our 2012-2013 budget quarterly budget forecast.